Question 1. In a situation where formal requirements conflict with evolving societal norms, a state government enacts a law prohibiting anonymous political donations over $1,000, arguing that transparency is necessary to prevent corruption. A group of political activists challenges the law, claiming it violates their First Amendment rights. How should a court evaluate the constitutionality of this law? A. The law is unconstitutional because anonymous donations are a form of protected speech and strict scrutiny applies. B. The law is constitutional because transparency in political contributions is a compelling government interest and disclosure laws are generally upheld. C. The law is unconstitutional because it discriminates against political speech, which requires a compelling justification under the overbreadth doctrine. D. Constitutional because it regulates only conduct, not speech, and thus only needs to pass rational basis review. Answer A. The law is unconstitutional because anonymous donations are a form of protected speech and strict scrutiny applies. Explanation. This question involves campaign finance laws and the First Amendment. The Supreme Court has ruled that political contributions are a form of speech under Buckley v. Valeo 1976, meaning that restrictions on contributions implicate the First Amendment, while transparency and preventing corruption are compelling interests. The means used to achieve them must be narrowly tailored. A. Correct. Anonymous donations are a protected form of political speech and restrictions on them must satisfy strict scrutiny. They must serve a compelling government interest and be narrowly tailored. The court has historically upheld disclosure laws, but not in ways that outright ban anonymous contributions over a certain amount. B. Incorrect. While transparency is important, the government must prove that banning anonymity is the least restrictive means of achieving its goal. Less restrictive alternatives, e.g., disclosure thresholds or oversight measures, might exist. Incorrect. The overbreadth doctrine applies when a law prohibits more speech than necessary, but this case is more about whether the restriction itself is too severe under strict scrutiny. D. Incorrect. The law regulates political speech, not just conduct, so rational basis review is insufficient. The court applies strict scrutiny to such cases. Thus, the court would likely strike down the law under strict scrutiny. Question 2. During a critical transition period where existing processes face legal challenges, a university adopts a policy requiring prior approval for any protests on campus, citing concerns about safety and disruption. A student group sues, claiming that the policy imposes an unconstitutional prior restraint. What is the most appropriate legal standard for evaluating the policy? A. The policy is unconstitutional because prior restraints are never allowed under the First Amendment. B. The policy is permissible if it is content neutral and imposes reasonable time, place, and manner restrictions. C. The policy is unconstitutional because government institutions cannot impose speech regulations on public property. D. The policy is constitutional because universities have broad discretion in regulating speech within institutions. Answer B. The policy is permissible if it is content neutral and imposes reasonable time, place, and manner restrictions. Explanation. This question tests knowledge of prior restraints, time, place, manner restrictions, and forum analysis. A. Incorrect. Prior restraints are disfavored, but they are not absolutely banned. Courts sometimes allow narrowly tailored restrictions to serve significant government interests, e.g., public safety. B. Correct. Universities can impose content neutral time, place, and manner restrictions as long as they meet the requirements set forth in Ward v. Rock Against Racism, 1989. They must be narrowly tailored, they must serve a significant government interest, they must leave open ample alternative channels for speech. Since the policy is content neutral and relates to safety, it could be upheld if it is not overly broad or vague. C. Incorrect. Public universities are considered limited public forums, meaning they can impose reasonable regulations as long as they do not target specific viewpoints. D. Incorrect. Universities do not have unlimited discretion. Any speech regulation must comply with First Amendment standards. Thus, the policy would be upheld only if it meets the three-part test for time, place, and manner restrictions. Question 3. When dealing with a complex system that shows occasional legal inconsistencies, a state legislature passes a law criminalizing online posts that contain knowingly false statements about public officials if they cause public unrest. A journalist is charged under the law for publishing a critical but inaccurate article about a governor. The journalist challenges the law as a violation of the First Amendment. What is the likely outcome? A. The law is unconstitutional because it imposes a prior restraint on speech and does not provide safeguards for press freedom. B. The law is unconstitutional because it criminalizes false statements without requiring proof of actual malice. C. The law is constitutional because knowingly false speech has no First Amendment protection. D. The law is constitutional because preventing public unrest is a compelling state interest. Answer B. The law is unconstitutional because it criminalizes false statements without requiring proof of actual malice. Explanation. This question addresses defamation, actual malice, and the limits of government regulation on false speech. The landmark case New York Times v. Sullivan, 1964, established the actual malice standard, which requires public officials to prove the statement was false and the publisher acted with malice ID. Knowing the statement was false or showing reckless disregard for the truth. A. Incorrect. The law does not impose a prior restraint, a legal order preventing publication in advance, but rather a punishment after publication. B. Correct. The law fails because it does not require proof of actual malice, meaning it could criminalize mere mistakes or negligent errors. Under United States v. Alvarez 2012, the Supreme Court ruled that false speech is sometimes protected, especially when criminalizing it could have a chilling effect on legitimate speech. C. Incorrect. Not all false statements are unprotected. If a law punishes falsehoods too broadly, it can deter truthful speech. Only defamation of public officials with actual malice is punishable. D. Incorrect. While preventing unrest is important, the law cannot restrict false speech without meeting strict scrutiny. Additionally, the public unrest justification is vague and may allow viewpoint-based suppression. Thus, a court would strike down the law as unconstitutional because it lacks an actual malice requirement, making it overly broad and a threat to press freedom. Question 4. During a comprehensive review of a process that needs improvement, a state government enacts a new law that prohibits online platforms from removing user-generated content based on political viewpoints. The law is challenged by several social media companies, arguing that it violates their First Amendment rights. The state defends the law, claiming it is necessary to prevent censorship and ensure a diversity of perspectives. Following is the most accurate legal analysis of this issue. A. The law is unconstitutional because it compels private companies to host speech they may not agree with, violating their First Amendment rights under the compelled speech doctrine. B. The law is constitutional because the government has an interest in ensuring diverse political viewpoints and preventing viewpoint discrimination. C. The law is constitutional because online platforms are public forums and the First Amendment prohibits censorship with public forums. D. The law is unconstitutional because it imposes a prior restraint on speech by restricting the platform's ability to remove content before publication. Correct answer. A. The law is unconstitutional because it compels private companies to host speech they may not agree with, violating their First Amendment rights under the compelled speech doctrine. Explanation. The First Amendment generally protects individuals from government restrictions on speech, but it does not apply in the same way to private entities, including social media platforms. The government cannot force a private company to host it does not agree with, as that would constitute compelled speech, violating cases such as West Virginia State Board of Education v. Barnett and Janus v. AFSCME. While the government may regulate speech in public forums, private platforms are not public forums under existing First Amendment jurisprudence. Manhattan Community Access Corp. v. Halleck. Option B is incorrect because preventing viewpoint discrimination is not a sufficient justification to override private companies' speech rights. Option C is incorrect because online platforms are not public forums and are not bound by First Amendment public forum rules. Option D is incorrect because prior restraint refers to government-imposed restrictions on speech before publication, which is not the issue in this case. Question 5. While analyzing the root causes of sequential problems in regulating religious practices, a school district allows students to form voluntary religious clubs but prohibits the use of school property for religious worship services. A religious student group challenges the policy, arguing that it violates the free exercise clause of the First Amendment. The school district argues that allowing religious worship services would violate the Establishment Clause by improperly endorsing religion. Which of the following is the strongest legal argument in favor of the school district's policy? A. The policy is unconstitutional because it treats religious groups differently from non-religious student clubs, violating the principle of viewpoint neutrality. B. The policy is constitutional because public schools cannot sponsor or appear to endorse religious worship services under the Establishment Clause. C. The policy is unconstitutional because the Supreme Court has ruled that religious organizations must have the same access to public spaces. Secular groups. D. The policy is constitutional because it prevents any expression of religious speech in school environment, which is necessary to maintain strict government neutrality. Answer. B. The policy is constitutional because public schools cannot sponsor or appear to endorse religious worship services under the Establishment Clause. Explanation. The Supreme Court has recognized that while religious groups have equal access to public forums, Widmer v. Vincent, a public school's involvement in religious worship services raises Establishment Clause concerns. Under Lemon v. Kurtzman, government action must 1. Have secular purpose, 2. Not advance or inhibit religion, and 3. Not foster excessive government entanglement with religion. The school's policy aims to avoid endorsement of religion. County of Allegheny v. A clue. Option A is incorrect because viewpoint neutrality applies to general speech rights but does not require schools to host religious worship. Option C is incorrect because equal access does not extend to allowing public schools to sponsor worship. Option D is incorrect because it misinterprets government neutrality. The government must be neutral toward religion, but it cannot actively suppress religious expression. Question 6. In a situation where formal requirements conflict with evolving technological realities, a journalist publishes classified government documents online, arguing that doing so is protected by the First Amendment's freedom of the press. The government seeks to prosecute the journalist under the Espionage Act, claiming the disclosure threatens national security. The journalist argues that publishing truthful, newsworthy information, protected under New York Times Company v. United States Pentagon Papers case. Which of the following is the most accurate legal analysis? A. The journalist is likely protected under the First Amendment because publishing truthful information, even if classified, is protected under New York Times Company v. United States. B. The journalist is not protected because the Pentagon Papers case only applied to prior restraint, and the government may still punish disclosures that harm national security. C. The journalist is protected because the government cannot impose any penalties on press for publishing information obtained from sources. D. The journalist is not protected because the press does not have greater First Amendment rights than individuals, and national security concerns override free speech. Answer. B. The journalist is not protected because the Pentagon Papers case only applied to prior restraint, and the government may still punish disclosures that harm national security. Explanation. While New York Times Company v. United States limited the government's ability to prevent publication through prior restraint, it did not grant absolute protection against criminal liability after publication. The Espionage Act has been upheld where disclosures cause substantial harm to national security. Schenck v. United States established that speech creating clear and present danger can be restricted. Option A is incorrect because post-publication penalties are different from prior restraint. Option C is incorrect because courts have recognized that journalists may still be prosecuted for certain disclosures. Option D is incorrect because while the press does not have special rights beyond individuals, First Amendment concerns must still be balanced against national security interests. Question 7. When addressing unforeseen challenges in the application of Fourth Amendment protections, law enforcement uses advanced drone surveillance to monitor a suspect's property from 400 feet above without a warrant. The suspect argues that this violates their reasonable expectation of privacy under the Fourth Amendment. The government claims that since the surveillance occurs from public airspace, no warrant is required. Which of the following reflects the legal precedent in this situation? A. The surveillance is unconstitutional because it constitutes an unreasonable search under the Katz test for reasonable expectations of privacy. B. The surveillance is constitutional because airspace above a person's home is not subject to privacy protections under California v. Ceriello. C. The surveillance is unconstitutional because drones represent a new form of technology that requires heightened Fourth Amendment protections under Carpenter v. United States. D. The surveillance is constitutional because public airspace is accessible to the public and law enforcement can use technology available to civilians without a warrant. Answer. B. The surveillance is constitutional because airspace above a person's home is not subject to privacy protections under California v. Suriello. Explanation: in California v. Suriello, the Supreme Court ruled that aerial surveillance conducted from public airspace does not violate the Fourth Amendment because individuals do not have a reasonable expectation of privacy in areas visible from above. However, emerging technology drones could lead courts to reevaluate this principle. Option A is incorrect because Katz v. United States established that privacy expectations must be objectively reasonable, and courts have ruled that open-air observation does not typically meet that standard. Option C is incorrect because Carpenter v. United States applied to cell phone tracking, not aerial surveillance. Option D is incorrect because although public airspace is accessible, the growing use of drones for persistent surveillance may present new legal questions. Question 8. Following an incident that reveals regulatory gaps, Congress passes a law banning all public criticism of government policies related to national security. A political activist is arrested under this law for posting online criticisms of the government's foreign policy. The activist challenges the law as an unconstitutional restriction on speech. Which of the following is the most accurate constitutional analysis? A. The law is unconstitutional because it violates the strict scrutiny standard, which requires the government to show a compelling interest and that the restriction is narrowly tailored. B. The law is constitutional because national security concerns allow the government to restrict speech under the clear and present danger test established in Schenck v. United States. C. The law is unconstitutional because the First Amendment provides absolute protection to political speech regardless of national security concerns. D. The law is constitutional because speech that undermines the government's authority can be restricted under the rational basis standard. Answer A. The law is unconstitutional because it violates the strict scrutiny standard, which requires the government to show a compelling interest and that the restriction is narrowly tailored. Explanation: the Supreme Court applies strict scrutiny to content-based restrictions on speech, meaning the government must show a compelling interest and that the law is narrowly tailored. A total ban on criticism of government policy is neither narrowly tailored nor the restrictive means of addressing national security concerns. United States v. O'Brien. Option B is incorrect because Schenck v. United States has been largely narrowed by later cases like Brandenburg v. Ohio, which protects speech unless it incites imminent lawless action. Option C is incorrect because while political speech receives the highest protection, not all speech is absolutely protected, e.g. incitement threats. Option D is incorrect because the rational basis test is not used for fundamental rights like free speech. Question 9. In an effort to balance competing interests in economic development and environmental protection, a state government imposes strict regulations on industrial emissions. A manufacturing company sues, arguing that the state regulations conflict with federal environmental laws. The state defends its law, claiming it has authority under the 10th Amendment to regulate industries within its borders. How should a court analyze this? A. The state law is invalid under the Supremacy Clause, which holds that federal law takes precedence over conflicting state laws. B. The state law is valid because the 10th Amendment allows states to regulate economic activity within their borders. C. The state law is invalid because only the federal government has the power to regulate commerce under the Commerce Clause. D. The state law is valid because it does not conflict with federal law, provides additional environmental protections. Answer D. The state law is valid because it does not conflict with federal law and provides additional environmental protections. Explanation: under the Supremacy Clause, states cannot pass laws that directly conflict with federal law. Gibbons v. Ogden, but they can impose stricter regulations that do not undermine federal law. California v. United States. If the state law complements rather than contradicts federal law, courts may uphold it. Option A is incorrect because not all state regulations conflict with federal law. Option B is incorrect because the 10th Amendment does not allow states to override federal environmental laws. Option C is incorrect because while the Commerce Clause gives Congress authority over interstate commerce, states can still regulate certain industries within their borders if no direct conflict exists. Question 10. When addressing unforeseen challenges in the application of the Equal Protection Clause, a state legislature enacts a new voting law requiring all voters to provide government-issued photo identification at polling stations. Civil rights groups challenge the law, arguing that it disproportionately affects minority and low-income voters who may lack such identification. What is the most appropriate constitutional analysis of this law? A. The law is unconstitutional because voting is a fundamental right and any restriction must pass strict scrutiny. B. The law is constitutional because the state has an interest in preventing voter fraud and the burden on voters is minimal. C. The law is unconstitutional because it has a disparate impact on certain groups even if no discriminatory intent is proven. D. The law is constitutional because voting laws fall under sovereignty and the federal government has limited authority to intervene. Answer: B. The law is constitutional because the state has an interest in preventing voter fraud and the burden on voters is minimal. Explanation: courts generally apply the Anderson-Burdick test to voting restrictions, balancing the burden on voters against the state's interest. Crawford v. Marion County Election Board. The Supreme Court has upheld voter ID laws, finding that preventing fraud is legitimate state interest and the burden is not restrictive. Option A is incorrect because strict scrutiny applies to laws that intentionally discriminate based on race. Shaw v. Reno, not general voting laws. Option C is incorrect because disparate impact alone does not make law unconstitutional without evidence of discriminatory intent. Washington v. Davis. Option D is incorrect because while states regulate elections, the federal government can intervene under the Voting Rights Act if laws are discriminatory. Question 11. Following an incident that reveals regulatory gaps, Congress passes a law requiring social media platforms to remove false or misleading statements about government policies. Journalist is penalized for criticizing federal agency, arguing that the law violates the First Amendment. What is the best constitutional analysis? A. The law is constitutional because false statements do not receive First Amendment protection. B. The law is unconstitutional because it is an overbroad restriction on speech and fails strict scrutiny. C. The law is constitutional because social media platforms are private companies and the First Amendment does not apply. D. The law is unconstitutional because it imposes prior restraint, which is always forbidden. Answer: B. The law is unconstitutional because it is an overbroad restriction on speech and fails strict scrutiny. Explanation: content-based speech restrictions are subject to strict scrutiny, meaning the government must have a compelling interest and use the least restrictive means. United States v. Alvarez. Laws broadly restricting false speech without defining intent or harm are likely unconstitutional. Option A is incorrect because false statements can be protected unless they cause direct harm, e.g., defamation, fraud. Option C is incorrect because while private platforms can regulate content, government mandates on speech trigger constitutional review. Option D is incorrect because while prior restraint, censorship before publication is generally disfavored near v. Minnesota, some exceptions exist, e.g. national security leaks. Question 12. In an effort to balance competing interests in economic stability and consumer protection, Congress passes a law capping credit card interest rates at 10%. A national bank challenges the law, arguing that it violates the Commerce Clause and preempts state regulations. What is the strongest legal argument for the bank? A. The law is unconstitutional because it violates the Dormant Commerce Clause, which prohibits excessive state regulation of interstate commerce. B. The law is unconstitutional because federal banking regulations preempt state consumer protection laws under the Supremacy Clause. C. The law is constitutional because Congress has broad authority to regulate interstate commerce, including banking practices. D. The law is unconstitutional because it interferes with the takings clause by reducing expected profits. Answer: C. The law is constitutional because Congress has broad authority to regulate interstate commerce, including banking practices. Explanation: Congress has broad authority under the Commerce Clause to regulate industries affecting interstate commerce. McCulloch v. Maryland. Banking regulations, including interest rate caps, fall within this power. Option A is incorrect because the Dormant Commerce Clause applies to state laws, not federal laws. Option B is incorrect because federal law does preempt state laws, but this case concerns a federal law, not a conflicting state law. Option D is incorrect because the Takings Clause applies to property, not regulations affecting profits. Penn Central Transportation Company v. New York City. Question 13. After careful evaluation of legal precedents concerning religious freedom, a public school refuses to allow a student religious group to meet on campus after hours, citing separation of church and state. The group sues, claiming a violation of the Free Exercise Clause. What is the strongest argument in favor of the student group? A. The school's policy violates the Free Speech Clause because it discriminates against religious viewpoints. B. The school's policy is constitutional because the Establishment Clause prohibits government endorsement of religion. C. The policy is unconstitutional because public schools must accommodate all groups equally under the Equal Protection Clause. D. The policy is constitutional because religious expression in public schools is strictly prohibited. Answer A. The school's policy violates the Free Speech Clause because it discriminates against religious viewpoints. Explanation. In Good News Club v. Milford Central School, the Supreme Court ruled that denying religious groups equal access to public facilities constitutes viewpoint discrimination under the First Amendment. The government cannot disfavor religious speech while allowing secular groups to meet. Option B is incorrect because allowing access is not the same as government endorsing religion. Option C is incorrect because equal protection generally applies to discrimination based on race, sex, or other protected statuses, not religious speech. Option D is incorrect because religious expression is allowed in schools as long as it is student-led and voluntary. Tinker v. Des Moines. Question 14. In an effort to address long-standing concerns regarding public safety, a state legislature enacts a law requiring all firearm owners to register their weapons in a statewide database. A group of gun owners files a lawsuit claiming that the law violates the Second Amendment. What is the most appropriate constitutional analysis of this law? A. The law is unconstitutional because any form of firearm regulation is prohibited under the Second Amendment. B. The law is constitutional because states have broad authority to regulate firearms for public safety. C. The law is unconstitutional unless the state can prove that it passes intermediate scrutiny by demonstrating a substantial government interest. D. The law is constitutional as long as it does not impose an undue burden on gun ownership. Answer C. The law is unconstitutional unless the state can prove that it passes intermediate scrutiny by demonstrating a substantial government interest. Explanation. The Supreme Court's ruling in District of Columbia v. Heller, 2008 affirmed an individual right to keep and bear arms, but also recognized that reasonable regulations, e.g. background checks, restrictions on felons are permissible. Most courts have intermediate scrutiny to gun regulations, meaning the law must further an important government interest in a way that is substantially related to that interest. Option A is incorrect because Heller does not prohibit all firearm regulations. Option B is incorrect because state authority to regulate firearms is not unlimited and must be balanced against constitutional rights. Option D is incorrect because the undue burden test applies to abortion regulations, Planned Parenthood v. Casey, not gun laws. Question 15. When evaluating the broader implications of workplace discrimination laws, Congress considers a proposal to prohibit employers from firing employees based on political affiliation. A private company fires an employee for publicly supporting a controversial political candidate. Would the proposed law be constitutional? A. Yes, because freedom of speech protections extend to political affiliation in all employment settings. B. No, because private employers are not bound by the First Amendment unless they are acting as state agents. C. Yes, because Congress has the authority to regulate workplace conditions under the Commerce Clause. D. No, because political beliefs are not a protected class under existing federal anti-discrimination laws. Answer B. No, because private employers are not bound by the First Amendment unless they are acting as state agents. Explanation. The First Amendment protects individuals from government action, not private employers, unless a company is acting on behalf of the government. State action doctrine, it can make employment decisions based on political affiliation. Boy. Scouts of America v. The Option A is incorrect because free speech protections generally do not apply to private employment decisions. Option C is incorrect because while Congress can regulate workplaces under the Commerce Clause, it does not have unlimited power over employment practices. Option D is incorrect because although political beliefs are not a protected class under federal law, some states do have protections for political affiliation. Question 16. In response to emerging legal and ethical concerns, a state government enacts a law requiring all social media companies operating within its jurisdiction to moderate content that is deemed offensive or inflammatory. Tech company challenges the law as an unconstitutional restriction on free speech. How should court evaluate the constitutionality of this law? A. The law is constitutional because states have an interest in protecting public discourse from harmful speech. B. The law is unconstitutional because it is vague and overbroad, violating the First Amendment. C. The law is constitutional because Social media platforms are private companies and can regulate speech as they see fit. D. The law is unconstitutional because only the federal government can regulate interstate commerce in online speech. Answer B. The law is unconstitutional because it is vague and overbroad, violating the First Amendment. Explanation: under Reno v. Eclue, 1997, vague laws regulating online speech violate the First Amendment. The terms offensive and inflammatory are not clearly defined, making the law overbroad and susceptible to arbitrary enforcement. Option A is incorrect because the government cannot censor speech based on subjective standards. Option C is incorrect because this case concerns state regulation of platforms, not the platform's own policies. Option D is incorrect because while the federal government has broad commerce powers, states may regulate businesses operating within their borders as long as the law is constitutional. Question 17. Considering the evolving landscape of healthcare regulations, Congress enacts a law requiring all insurance providers to cover gender-affirming care for transgender individuals. A religiously affiliated insurance company challenges the law, arguing that it violates the Religious Freedom Restoration Act, or R. What is the most appropriate legal analysis? A. The law is unconstitutional because it imposes a substantial burden on religious beliefs, violating OE. B. The law is constitutional because healthcare regulations do not trigger religious freedom protections. C. The law is unconstitutional because it forces private businesses to act against their religious convictions, violating the Free Exercise Clause. D. The law is constitutional because the government has a compelling interest in ensuring access to healthcare. Answer D. The law is constitutional because the government has a compelling interest in ensuring equal access to healthcare. Explanation: under Burwell v. Hobby Lobby 2014, RA prohibits laws that place a substantial burden on religious exercise unless the government has a compelling interest and uses the least restrictive means. Courts have generally found that ensuring non-discriminatory healthcare access is a compelling government interest. Option A is incorrect because while RA protects religious exercise, the government can override it for compelling reasons. Option B is incorrect because healthcare laws can implicate religious freedom, e.g. contraceptive mandates. Option C is incorrect because not all burdens on religious business owners are unconstitutional, e.g. anti-discrimination laws apply to religious businesses in many contexts. Question 18. To ensure consistency in legal interpretations, the Supreme Court considers a case challenging the qualified immunity doctrine, which protects government officials from lawsuits unless they violate a clearly established right. Citizen sues police officer for excessive force but loses because no identical prior case exists. How should the court evaluate whether to modify the qualified immunity doctrine? A. The doctrine should be narrowed because requiring identical precedent makes it impossible to hold officials accountable. B. The doctrine should be upheld because it protects officers from frivolous lawsuits that could hinder law enforcement. C. The doctrine should be eliminated entirely, as it allows constitutional violations to go unchecked. D. The doctrine should be expanded to further shield government officials from all personal liability. Answer: A. The doctrine should be narrowed because requiring identical precedent makes it impossible to hold officials accountable. Explanation: the qualified immunity doctrine has been criticized for requiring plaintiffs to show clearly established law, often interpreted to mean a prior case with almost identical facts. Taylor v. Riojas 2020. Critics argue this makes it too difficult to hold officials accountable. Option B is incorrect because while protecting officers is important, excessive force cases show that the doctrine is often applied too broadly. Option C is incorrect because eliminating all immunity could lead to frivolous lawsuits against government officials. Option D is incorrect because further expanding immunity would make it even harder to sue officials who violate constitutional rights. Question 19. Given the increasing complexity of election security concerns, Congress enacts a law requiring all states to use only federally approved electronic voting machines in federal elections. A group of state election officials files a lawsuit arguing that the law violates the 10th Amendment. How should a court evaluate the constitutionality of this law? A. The law is unconstitutional because it infringes on state sovereignty under the 10th Amendment. B. The law is constitutional because Congress has broad power to regulate federal elections under the Elections Clause. C. The law is unconstitutional because the federal government does not have the power to regulate election security. D. The law is constitutional only if it applies exclusively to presidential elections and not congressional elections. Answer B. The law is constitutional because Congress has broad power to regulate federal elections under the Elections Clause. Explanation. The Elections Clause, Article I, Section 4, gives Congress the authority to regulate the times, places, and manner of federal elections. Courts have upheld Congress's power to standardize election procedures to prevent fraud and ensure fairness. Arizona v. Intertribal Council of Arizona, 2013. Option A is incorrect because the 10th Amendment does not override explicit congressional powers over federal elections. Option C is incorrect because the federal government can regulate elections under the Elections Clause. Option D is incorrect because Congress's power extends to all federal elections, not just presidential ones. Question 20. In an effort to ensure transparency and accountability, Congress passes a law requiring all social media platforms to disclose the identity of users who post false or misleading information about elections. A journalist sues, arguing that the law violates the First Amendment. Which constitutional principle is most relevant in assessing the legality of this law? A. The law is unconstitutional because it chills free speech and discourages anonymous political discourse. B. The law is constitutional because preventing election misinformation is a compelling government interest. C. The law is unconstitutional because it violates the Fourth Amendment right to privacy. D. The law is constitutional because social media companies are private entities that do not have First Amendment protections. Answer A. The law is unconstitutional because it chills free speech and discourages anonymous political discourse. Explanation. The Supreme Court has recognized that anonymous political speech is protected under the First Amendment. McIntyre v. Ohio Elections Commission, 1995. Requiring social media companies to disclose user identities could deter people from engaging in protected speech even if the law targets misinformation. Option B is incorrect because while combating misinformation is important, the law must be narrowly tailored to avoid chilling speech. Option C is incorrect because this is primarily a First Amendment issue, not a Fourth Amendment privacy issue. Option D is incorrect because the law applies to government regulation of speech, not how private companies operate. Question 21. Taking into account the historical evolution of free speech protections, a public university implements a policy requiring all student organizations to receive pre-approval before hosting political events on campus. A student group challenges the policy, arguing that it constitutes prior restraint. What is the most appropriate constitutional analysis? A. The policy is unconstitutional because it imposes prior restraint on speech violating the First Amendment. B. The policy is constitutional because universities have broad discretion to regulate campus events. C. The policy is unconstitutional unless the university provides a clear and neutral approval process. D. The policy is constitutional because public universities are not bound by the First Amendment in the same way government entities. Answer A. The policy is unconstitutional because it imposes prior restraint on speech violating the First Amendment. Explanation. The Supreme Court has ruled that prior restraints on speech are presumptively unconstitutional. Near v. Minnesota, 1931. Public universities, as government-funded institutions, cannot require pre-approval for political speech without violating the First Amendment. Option B is incorrect because public universities are government entities subject to constitutional limits. Option C is incorrect because even a neutral approval process could still be an unconstitutional prior restraint. Option D is incorrect because public universities must uphold free speech rights. Question 22. Acknowledging the role of economic policies in national security, Congress passes a law banning all Chinese-owned companies from acquiring American technology firms. A Chinese company sues, arguing that the law violates equal protection under the Fifth Amendment. How should the court evaluate the constitutionality of this law? A. The law is unconstitutional because it discriminates based on national origin, violating equal protection. B. The law is constitutional because economic regulations are subject to only rational basis review. C. The law is unconstitutional because it violates the Commerce Clause. D. The law is constitutional only if it is narrowly tailored to a legitimate security interest. Answer B. The law is constitutional because economic regulations are subject to only rational basis review. Explanation. Economic regulations are generally subject to rational basis review, meaning the government only needs a legitimate reason for the policy. FCCV. Beach Communications, 1993. National security concerns provide a rational basis for the law. Option A is incorrect because foreign companies do not have the same constitutional protections as U.S. citizens. Option C is incorrect because Congress has broad power over foreign commerce. Option D is incorrect because narrow tailoring applies to strict scrutiny, which does not apply here. Question 23. In light of the shifting legal landscape regarding drug policies, a state legalizes recreational marijuana while maintaining strict penalties for possession near schools. The defendant is arrested 50 feet from a school and challenges the law as unconstitutionally vague. What is the most appropriate constitutional analysis? A. The law is unconstitutional because it lacks a clear definition of how far from a school is illegal. B. The law is constitutional because states can regulate drug possession under their police powers. C. The law is unconstitutional because marijuana is legal in the state. D. The law is constitutional because it does not target any protected class. Answer B. The law is constitutional because states can regulate drug possession under their police powers. Explanation: states have broad police powers to regulate public safety, including drug laws. Gonzalez v. Raich, 2005. The law clearly defines the prohibition and does not impose an arbitrary standard. Option A is incorrect because the law specifies the school zone. Option C is incorrect because states can have differentiated laws for drug use. Option D is incorrect because vagueness is an issue regardless of protected class status. Question 24. During a critical transition period where existing processes are being updated to align with new federal regulations, a company introduces AI-driven hiring software that screens applicants automatically. However, multiple complaints arise that the software disproportionately filters out minority candidates. How should the company address potential discriminatory hiring practices under federal law? A. The company should immediately discontinue the AI system and revert to manual hiring. B. The company should conduct a disparate impact analysis to determine if the software violates Title IX of the Civil Rights Act. C. The company is not responsible since the hiring process is automated and not intentionally discriminatory. D. The company should implement additional AI training but is not legally required to change its hiring. Answer B. The company should conduct a disparate impact analysis to determine if the software violates Title IX of the Civil Rights Act. Explanation: under Title IX of the Civil Rights Act of 1964, employment practices that disproportionately exclude protected groups, even if unintentional, may constitute disparate impact discrimination. The Equal Employment Opportunity Commission (EOC) advises companies to assess whether AI systems introduce bias and take corrective action if necessary. Option A is incorrect because discontinuing AI without evaluation is not required. Option C is incorrect because intent is not necessary for disparate impact claim. Option D is incorrect because additional AI training alone does not resolve potential legal violations. Question 25. While investigating a complicated issue between different state agencies, policymakers discover that some states have significantly stricter environmental regulations than federal guidelines. A corporation challenges a state law that imposes higher emission standards, arguing that it conflicts with federal law. How should the court determine whether the state law is preempted? A. The state law is automatically invalid because federal law supersedes all state laws on the issue. B. The court should apply the preemption doctrine to determine whether the federal government intended to occupy the field. C. The court should only invalidate the state law if Congress explicitly banned stricter state regulations. D. The court should defer to state authority because environmental laws are not within federal jurisdiction. Answer B. The court should apply the preemption doctrine to determine whether the federal government intended to occupy the field. Explanation: the Supremacy Clause, Article Romance, establishes that federal law preempts conflicting state laws. Courts apply the preemption doctrine to determine whether federal law fully occupies a policy area, field preemption, or whether a state law directly conflicts. Conflict preemption. Option A is incorrect because not all state laws are automatically preempted. Option C is incorrect because implicit preemption can also occur without an explicit federal ban. Option D is incorrect because environmental regulation often involves both state and federal authority. California v. EPA, 2008. Question 26. In a high-stakes environment where multiple challenges must be managed simultaneously, an agency implements a new cybersecurity protocol that mandates strict two-factor authentication. However, the system frequently locks out authorized personnel, delaying critical functions. What is the most effective approach to balancing security and accessibility? A. Reduce authentication requirements to ensure continuous access. B. Maintain strict security protocols and require users to adapt. C. Conduct a risk-benefit analysis to determine if adjustments can be made without compromising security. D. Remove the authentication system and rely on alternative security measures. Answer C. Conduct a risk-benefit analysis to determine if adjustments can be made without compromising security. Explanation. Security policies must be effective but also practical. A risk-benefit analysis ensures that security measures are optimized while minimizing operational disruptions. Agencies must assess whether authentication processes can be refined without introducing vulnerabilities. NIST cybersecurity framework. Option A is incorrect because weakening authentication compromises security. Option B is incorrect because forcing adaptation without flexibility can reduce efficiency. Option D is incorrect because completely removing authentication eliminates protections. Question 27. In an environment where different components must interact, a hospital transitions to a fully digital medical record system. However, different departments use incompatible software, causing errors in patient data transfer. What is the best approach to ensuring seamless data integration? A. Require all departments to switch to a single vendor. B. Develop a customized interoperability solution that enables seamless data exchange. C. Allow departments to continue using their existing systems and handle discrepancies manually. D. Maintain separate databases for different departments and only merge data when needed. Answer B. Develop a customized interoperability solution that enables seamless data exchange. Explanation. The Health Information Technology for Economic and Clinical Health (HITECH) Act encourages interoperability to ensure efficient healthcare data sharing. Developing an interoperability solution enables different systems to communicate without requiring a full transition to a single vendor. Option A is incorrect because forcing all departments to switch could be costly and disruptive. Option C is incorrect because manual handling increases errors and inefficiencies. Option D is incorrect because separate databases reduce real-time data accuracy. Question 28. When scaling up operations that experience significant logistical delays, a national retailer adopts a predictive analytics model to optimize supply chain performance. However, the model fails to account for regional demand fluctuations, causing overstocking in some locations and shortages in others. What corrective strategy should the retailer pursue? A. Discontinue the predictive analytics model. B. Implement a hybrid system that combines AI predictions with manual adjustments based on local data. C. Standardize inventory nationwide to simplify distribution. D. Rely solely on regional managers to oversee inventory decisions. Answer B. Implement a hybrid system that combines AI predictions with manual adjustments based on local data. Explanation. AI-driven models can improve efficiency, but human oversight is crucial to address unexpected factors. A hybrid system allows the retailer to leverage data analytics while incorporating local expertise. Option A is incorrect because AI can still be valuable with improvements. Option C is incorrect because uniform inventory ignores regional variations. Option D is incorrect because relying solely on human oversight limits scalability. Question 29. During an emergency response where multiple areas are impacted, a federal agency deploys disaster relief resources. However, rural communities report delays in receiving aid compared to urban centers. What is the most effective strategy to ensure equitable disaster response? A. Prioritize resources for densely populated areas where more people are affected. B. Use geospatial data and local partnerships to ensure balanced resource allocation. C. Rely on pre-existing response protocols without adjustments. D. Focus on large cities first and extend aid to rural areas once urban centers are stabilized. Answer B. Use geospatial data and local partnerships to ensure balanced resource allocation. Explanation. Disaster response should be equitable, ensuring timely aid for all affected regions. Geospatial analysis and local coordination improve efficiency by targeting specific needs. Agencies like FEMA use similar methods to ensure fair distribution. Option A is incorrect because it prioritizes population over urgency. Option C is incorrect because response plans must be adaptive. Option D is incorrect because delaying rural aid worsens disparities. Question 30. In a situation where formal requirements conflict with practical constraints, a multinational corporation faces challenges in complying with new international data privacy regulations. The company operates in multiple jurisdictions, each with different compliance requirements, making uniform implementation difficult. What is the best approach to ensuring compliance while maintaining operational efficiency? A. Apply the strictest regulations company-wide, even in jurisdictions with less stringent requirements. B. Develop a modular compliance framework that allows for regional adaptations while maintaining core privacy protections. C. Focus on meeting only the most lenient requirements, as stricter regulations may not be enforced universally. D. Outsource data processing to a third-party provider that assumes full responsibility for compliance. Answer: B. Develop a modular compliance framework that allows for regional adaptations while maintaining core privacy protections. Explanation: a modular compliance framework ensures the company meets local legal obligations while maintaining consistent privacy standards. Regulations like the EU General Data Protection Regulations (GDPR) and California Consumer Privacy Act (CCPA) require companies to adapt to different legal frameworks. Option A is incorrect because applying the strictest rules may be unnecessarily restrictive in some locations. Option C is incorrect because failing to meet higher standards could lead to penalties and reputational damage. Option D is incorrect because companies remain legally accountable for third-party data handling.